get your sister's phone number, your phone number and address tomorrow morning before you call in, and then they'll be able to put that in their file, okay? All right, so you're going to be randomly screened for drugs and alcohol, which means that you cannot use drugs or alcohol while your case is pending. You understand? There's an initial screen for drugs. That'll be your baseline, but if on later testing, the levels don't go down, but instead stay the same, get higher, or there's a new drug or alcohol introduced, you could be violated. Do you understand? Yeah. And I will provisionally appoint the Office of the Public Defender to represent you during the pandemic, sir. Once COVID is over, you will need to reapply to make sure they keep representing you. Anything else in Mr. Baxter's case that we need to address?
That's it.
All right, good luck to you, Mr. Baxter. All right, next is Mr. Lewis on page 17 that they've asked that we take out of turn for medical reasons.
Be careful, be careful. You can hold on to the hold on.
All right, Mr. Lewis, good morning, sir. Yeah. I do find probable cause count 1 petty theft in the first degree over 100 but less than $750. Count 2 should be a possession of a stolen driver's license, not forged. Actually, it was fixed on the it's fixed on the findings, but the docket's wrong for some reason. 3 and 4 are capiases, misdemeanor capiases for theft. Mr. Linder, first to you, sir.
One moment.
No problem. Let me turn this.
Your Honor, I'm asking that the court keep the bond in place. In addition to the 2 pending petty thefts that he failed to appear in court on, he also has a pending felony petty theft. He was on pretrial, but his pretrial was revoked on that case when he picked up the new petty thefts that he failed to, the new petty theft that he failed to appear in court on. He was given a bond in place of pretrial, which he posted. So he's already shown while on pretrial that he's committing new law offenses and now again committing new theft-related offenses.
Thank you, Mr. Linder. Mr. Romero.
I spoke to Mr. Lewis. He's been residing here in our community since 1993. He is disability. He has a place to live. He lives in Ohio with the roommate. He's been there for the past 6 months. Judge, when I inquired as far as why he missed court, unfortunately, he suffered a stroke. And it's led to several medical issues. Or my understanding in speaking to him, he's been on several medications. Sometimes those medications have him feeling drowsy and affects his memory. That is why he told me he missed court. Not that he didn't want to go to court. He is asking at this time because there's nobody that can help post his monetary bond at this time, Judge. He's asking if the court would consider releasing him on pretrial. Also, if the court is not inclined, Judge, we're going to be asking for a medical screening order on Mr. Lewis's behalf and to be provisionally appointed on his cases.
Great, thank you. Mr. Linder, when his pretrial was revoked on the felony petty theft, is he being held no bond or does he have a monetary amount?
No, he was given a bond and he posted that bond. That's what he's out on now.
Okay, thank you. All right. Look at
And just to advise the court, what he was given $850 total bond on that case because there was also a count of false ID to law enforcement. His bond on the new petty theft was raised to $750 and he posted a $1,600 bond.
All right, with this now being the 4th pending case, I'm trying to see when was his medical issue, Mr. Romero?
Let me inquire, Judge.
Thank you.
Judge, thank you for giving me that time. He said it was approximately 2 weeks ago.
Okay, thank you. That's about when that capias was issued. Hold on, let me look at when the other one was issued.
25th.
Sorry?
May 25th.
Okay, for the 21 case,
Yes.
the 2020 case, I mean.
Yes.
Okay, so the 20 case was issued in May. However, the 21 case was issued last month, about 2 weeks ago on the 30th. So I'm not going to touch the one where the KPS was issued on May 28th, 2021. He said he has a place to live, actually.
That is correct, Judge. He said he's residing in Fort Lauderdale with a roommate.
All right, so what I'll do is I'll put him on pretrial level 2 with a monitor for all of these counts and all of these cases. And sir, you can now go back to that Publix as a condition of your release. Do you understand?
Yes, ma'am.
All right, so I'm going to ROR him to pretrial release level 2 with a GPS on all of the counts, all of the cases. That means that you can go to your medical appointments, you can go to try to find a job if you're able to, if you're medically able to, and go to court, but you need pre-approved scheduling from your pretrial officer, okay, unless it's an emergency, understood?
Yes, ma'am.
All right, and I will provisionally appoint the Office of the Public Defender to represent you during the pandemic, sir. Once COVID is over, you will need to reapply to make sure that they keep representing you, understood?
Yes, ma'am.
All right, anything else on Mr. Lewis's case that we need to address?
I'm still going to be asking for that medical screening order.
Okay, not a problem. I'll sign that medical screen order as well. Good luck to you, Mr. Lewis. All right, so that's it for out of turns. We're going to start on page 1. Just give me 1 minute to finish this. All right, here we go. All right, so page 1, Miss Jarrett.
Next to me, Judge.
All right, thank you. Good morning, ma'am. Good morning, Judge. Did you find the probable cause for touch strike battery, domestic violence? Mr. Linder, first to you.
Submitting ROR to pretrial, no victim contact.
Okay, thank you. Mr. Romero.
Judge, at this time, no objection. I'm going to be asking for 2 things, Judge. My understanding is her and the victim are residing together. She needs to go back one time with law enforcement to retrieve her property. Also, she is a stay-at-home mom taking care of the kids. Judge, I'm going to be asking for an exception to the no contact order for purposes of arranging child issues, contact to a third person for that one limited reason.
So I'm actually not going to do anything with that because it looks like DCF was called. She'll have to go before her dependency judge because DCF was called. It's in the reports.
Your Honor,
Yes.
just for the record, and I don't know if it makes a difference to the court, but it does appear that they advised they would not be taking the case.
Okay, thank you. It does. Okay, thank you. So I did miss that. Does the state wish to be heard with regard to that exception then?
No, Judge.
All right, thank you. So, okay, I will grant that exception then. Thank you for clarifying that. All right. So, ma'am, I am going to order that you cannot possess any firearms, weapons, or ammunition while your case is pending because of the domestic violence nature. Do you understand?
Yes, ma'am.
All right. You also cannot have any contact with the alleged victim, direct or indirect, while your case is pending. And I will give you one exception, except for third-party contact regarding child care or child custody. Do you understand? All right, and that means that otherwise you cannot call the victim, you cannot text him, email, social media, live with them, letters, any family members or friends sending a message to him, except regarding childcare or any other means of communication that I have not said. Do you understand?
Yes, ma'am.
All right, you also, I'll give you that one-time allowance to go to the home for the city within which you used to live with the alleged victim and the children. That means that you can go one time with law enforcement from the Hollywood Police Department with the order that grants you a one-time allowance to go to the home to get your belongings to live separately. You have to go with police or else you could be in violation of this order. Do you understand?
Yes, ma'am.
All right, anything else on her case? Does your office need to be appointed?
Yes, Judge.
All right, no problem. I will provisionally appoint the Office of the Public Defender to represent you during the pandemic, ma'am. Once COVID is over, Ms. Jarrett, you will need to reapply to make sure that they keep representing you. Good luck to you. Yes, I did standard pretrial. My apologies. You're going to, number, sorry. All right, thank you for that reminder, Ms. Worrell. Ms. Jarrett, before you, ma'am, I did need to advise you about pretrial. Wait, hold on, sorry. Ms. Jarrett, you're going to be released today, but you have to call into pretrial before 11 a.m. tomorrow. So please give pretrial your phone number so they have it on file. My apologies, ma'am.
954-607-9776.
All right. Good luck to you, Ms. Jarrett.
You got it already? I'm sorry, I gave it to you. Sorry. You were already given it.
All right, next is Ms. Davis on page 1.
Ms. Davis, come on up, please. She's approaching Judge Jeremy.
Okay, thank you. Ms. Jarrett, good morning, ma'am. Sorry, Ms. Davis, we just did Ms. Jarrett. Ms. Davis, good morning, ma'am. I do find probable cause for battery, caused bodily harm, domestic violence. However, please note, based on the allegations, there's a potential that the state could file charges as an aggravated battery deadly based on the use of bottles as a deadly weapon. But that being said, I will take that into account when setting bond, but I will not change the charge at this time based on what's been presented. Mr. Linder, first to you, sir.
Your Honor, I'm recommending a $1,500 bond no victim contact without knowing more about what kind of bottle allegedly was thrown. But it does appear that Ms. Davis does not have ties to the area, as the paperwork indicates she resides in the state of Michigan. Nothing further.
Okay, thank you. Mr. Romero, does she in fact reside in, does she need an order to go back there?
That is correct, Judge. She's here on vacation. She was actually scheduled to go back today. She will be going back to Detroit. Now, her and the alleged victim do not live together. I did go over as far as the no contact. That's not going to be a problem. We're going to be asking to be provisionally appointed. She will contact her assigned public defender and appear in court in order to go ahead and contest these allegations. But as far as $1,500 bond, that's reasonable at this time, Judge.
All right, thank you. So Ms. Davis, I am going to set your bond in the amount of $1,500. The conditions of your bond, even while you are in custody, ma'am, you cannot have any contact, direct or indirect, with the listed victim. Do you understand?
Nice and loud.
Yes.
All right, and that means that you cannot call her, text her, email, social media, have a family member or friend send a message to her, or any other means of communication. Do you understand?
Yes.
You also cannot possess any firearms, weapons, or ammunition while your case is pending based on a domestic violence nature. Do you understand?
Yes.
And it looks like there was alcohol involved, but you are going back to Michigan. So I won't do anything with regards to that at this time. But ma'am, I will give you an allowance to return to Michigan while your case is pending. But be in touch with your assigned public defender, because there are times that you're going to have to be back in the state to answer to these charges if the state does file. So I will provisionally appoint the Office of the Public Defender to represent you during the pandemic. Once COVID's over, you'll need to reapply to make sure they keep representing you. Yes, Ms. Cooper?
Judge, if you can attach this to the booking report, the offense report number was corrected. So at the top, it needs to go with the clerk's paperwork for.
Okay, no problem. So I will, do you just want me, okay, thank you. So I will put this corrected booking report on the back of Ms. Davis. Okay. All right, anything else in Ms. Davis's case that we need to address?
No, Judge.
All right, good luck to you, Ms. Davis. All right, next is Ms. Jackson on page 2.
Ms. Jackson, Kiara, come on up, please. Who's approaching, Judge?
Thank you. All right, Ms. Jackson, good morning, ma'am. I do find probable cause for touch or strike battery, domestic violence or dating violence, possession with intent to sell or deliver cocaine, count 2. Mr. Linder, first to you, sir.
Your Honor, I'm recommending a $1,000 bond on count 1 with no victim contact, ROR to pretrial with random testing on count 2. It's based on the allegations in the report. Also, Ms. Jackson was arrested earlier this year for an aggravated battery against a victim over the age of 65. Charge was dropped just a couple weeks ago, or a few weeks ago, June 21st. Nothing further.
Okay, thank you. Mr. Romero.
Judge, no objection as to the bonds requested by the state. What I'm going to be asking for is a phone order, and I'm going to be asking to be provisionally appointed on her case, Judge.
All right, thank you. I'll sign that phone order, and I will also provisionally appoint the Office of the Public Defender to represent you during the pandemic, Ms. Jackson. Once COVID is over, you will need to reapply to make sure that they keep representing you. On count 1, I will set bond in the amount of $1,000. Count 2, I will release you to pretrial release. So please give your phone number to pretrial before I get my orders. That's the entire case on pretrial, so there's no confusion. So on count 1, it'll be bond plus pretrial. Okay, so what's your phone number, Ms. Jackson?
Judge, it is 239-990-1282.
Did you get them, Ms. Worrell?
Yes, Your Honor.
All right, thank you. All right, Ms. Jackson, the conditions of your bond and pretrial, ma'am, are that you cannot have any contact, direct or indirect, with the listed victim. Do you understand?
very soft-spoken, Judge.
Okay, so did she acknowledge?
Yes, Judge.
All right, thank you. That means, Ms. Jackson, you cannot live with her, call her, text her, email, social media, letters, have a family member or friend send a message to her, or any other means of communication that I have not said. Do you understand?
A little louder, Ms.
Yes,
House.
ma'am.
All right, you also cannot possess any firearms, weapons, or ammunition while your case is pending based on a domestic violence nature. Do you understand?
Yes, ma'am.
All right. I will also, with regards to the drug charge, ma'am, you are going to be randomly screened for drugs and alcohol. That means that you cannot use drugs and you cannot use alcohol while your case is pending because you are going to be randomly screened. Do you understand?
Yes, ma'am.
She answered in the affirmative, Judge.
Okay, thank you. Anything else on her case that we need to address?
Yes, Judge, I did get the last digit incorrect on the phone number I gave you. It is 83, not 82, Judge. I apologize.
Okay, no problem. So Ms. Worrell, the last digit is 3.
Got it.
Okay, thank you. All right, good luck to you, Ms. Jackson. Next, Ms. Lind on page 3 is a medical reset, so hopefully she feels better tomorrow. Next is so that's all of it. Okay, next is Ms. Hicks on page 4.
Judge, Ms. Lind, I was going to be asking for a mental health screening order.
Okay, that's fine. I'll sign a mental health screen on Ms. Lind on page 3. Ms. Edgley, if you want to do that, I'll sign it even though she's still a medical reset. No problem. All right, next is Ms. Hicks on page 4.
Here next to me, Judge, Amin.
Thank you, Ms. Hicks. Good morning, ma'am. I do find probable cause for false ID to Leo operating without a valid driver's license and a Capias for operating without a valid driver's license. Mr. Linder, does the state have an offer this morning if she wishes to resolve?
Yes, Your Honor. If she wishes to resolve, 1 and 2 would be an adjudication time served. If she wishes to resolve 3, it'd be a withhold court cost. If she's not inclined to resolve the charges, the recommendation would be an ROR to pretrial on all the counts.
Okay, thank you. So, Mr. Romero, whenever she makes a decision, just let me know.
Judge, in speaking to her, we did speak about this. I did advise her what her options are. At this time, she wishes to accept the state's offer in exchange for a no contest plea, Judge.
All right, thank you so much. Ms. Hicks, please raise your right hand for me to the best of your ability, ma'am. Do you swear or affirm to testify to the truth, the whole truth, and nothing but the truth?
Yes.
All right, ma'am, thank you. You can put your hand down and state your name for the record. Ms. Hicks, it's my understanding that you wish to resolve both of these cases, correct?
Yes.
Do you understand the charges against you?
Yes.
And do you understand everything that's happened here today? Is anyone forcing you to resolve either of these cases? Sorry, can't hear you.
I'm sorry.
It's okay. No need to apologize. Are you under the influence of alcohol or drugs today?
No.
Do you need more time to speak to your attorney?
It's not that I want to talk to you. Do you want to talk to me?
Just 1 second.
One moment, Judge.
No problem. Take your time.
All right, let the judge know that you
I,
spoke to me.
oh yes, I spoke to him and I'm going to proceed.
Okay, so you wish to continue with your plea, correct?
Yes.
Okay, not a problem. And do you understand you have a right to go to trial and to fight each of these charges, but you're giving up that right forever by accepting the state's offer?
I understand.
Have you ever been treated for a mental or emotional illness?
No.
And I'm not asking if you're a United States citizen. I just have to advise everybody that takes a plea before me. Do you understand if you're not a United States citizen that taking this plea today shall subject you to deportation proceedings?
I know.
Okay, and how do you wish to plead, guilty or no contest?
No contest.
All right, ma'am, I do accept your no contest pleas as freely, voluntarily, knowingly given on counts. And I also find there's a factual basis for each of these counts. And I will sentence you on counts 1 and 2 to an adjudication time served, both counts to run concurrent with each other. Okay, and on count 2, I will sentence you to a withhold of adjudication and court cost. And Mr. Romero, with regards to court cost, how much time does she need to pay?
1 year, Judge.
All right, and I will give you 1 year to pay the court cost of prosecution, and PD application fee. Good luck to you, Ms. Hicks. If nothing else is holding you, you should be released today.
Just to clarify, because on 2, you said time served, but then you turned around and said withhold.
On count 3.
Count 3.
Count 3 is a withhold. Sorry about that. Count 3 is a withhold court cost, just so we're clear. My apologies for any confusion. All right, so next is Miss Davis on page 5.
Approaching judge next to me.
All right, thank you, Ms. Davis. Good morning, ma'am. I do find probable cause for operating without a valid driver's license. Mr. Linder, does the state have an offer which she wishes to resolve?
Adjudication time served.
Okay, thank you. Mr. Romero?
Speaking Ms. Davis, she wishes to accept the state's offer.
All right, thank you. Ms. Davis, please raise your right hand for me to the best of your ability. Do you swear or affirm to testify to the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, thank you. You can put your hand down. Ms. Davis, it's my understanding that you wish to resolve your case today, correct?
Yes,
And do you understand the charges against you?
yes, ma'am.
And is anyone forcing you to resolve this case today?
No, ma'am.
Are you under the influence of alcohol or drugs today?
No, ma'am.
And do you need more time to speak to your attorney, Mr. Romero?
No, ma'am, that's fine.
All right, and you'll let me know if that changes, right?
Yes, ma'am. Thank
All right.
you.
Sorry?
No, I said, yes, ma'am, thank you.
All right, not a problem. And do you understand you're forever giving up your right to go to trial and fight this charge by accepting the state's offer?
Yes, ma'am.
Have you ever been treated for a mental or emotional illness?
No, ma'am.
I'm not asking if you're a citizen. I just have to advise everybody that comes before me for a plea. Do you understand if you're not a United States citizen, that taking a plea today shall subject you to deportation proceedings?
Yes, ma'am, but I am a U.S. citizen.
All right, no problem. Ms. Davis, how do you wish to plead? Guilty or no contest?
No contest.
All right, I do accept your no contest plea is freely, voluntarily, knowingly given. I also find there's a factual basis for this plea based on the probable cause affidavit, and I sentence you to an adjudication time served. And how much time does she need to pay, Mr. Romero?
1 year, judge.
All right, and I'll give you 1 year to pay those court costs, cost of prosecution, PD application fee. Ms. Davis, good luck to you. If nothing else is holding you, ma'am, you should be released today. Next is Ms. Tersch on page 6.
She's approaching judge.
Okay, thank you, Ms. Tersch. Good morning, ma'am. I do find probable cause. Count 1 is trespassing. Count 2 is grand theft over $750, but less than $5,000. Mr. Linder, first to you.
Your Honor, the state would recommend ROR to pretrial and no return, but Ms. Tersch needs to understand this will be the last time that the state recommends non-monetary release for any incident that she has at the airport, Your Honor. As you can see, both of these incidents involve the airport. She has an open trespass and disorderly conduct from the airport. She had resisting without violence and disorderly conduct last year at the airport. She keeps getting told by judges and law enforcement not to go back there, and she refuses to listen to their instructions.
All right, thank you, Mr. Linder. Mr. Romero.
Judge, no objection. Considering she is on disability, we're going to be asking to be provisionally appointed on her case, Judge.
All right, thank you. So, Ms. Tersch, I am going to release you to pretrial release. Do you have a phone number that you can give?
Yes.
Say your number nice and loud.
94, is my number?
Yes,
I don't have a number.
then your boyfriend's number.
Okay, 954-793-6133.
And what's his name?
Nelson Michael.
Okay, did you get them, Ms. Worrell?
Yes, Your Honor.
All right, thank you. All right, ma'am, you cannot have any contact with the listed victim of the grand theft, direct or indirect. You may not know who she is, but you cannot call, text, email, social media, have a family member or friend send a message to her or any other means of communication that I have not sent. Do you understand?
Yes,
You also cannot return to Fort Lauderdale Airport. Do you understand?
yes,
And I will provisionally appoint the Office of the Public Defender to represent you during the pandemic, ma'am. Once COVID is over, you'll need to reapply to make sure they keep representing you. Good luck to you, Ms. Tersch. You're being released today. Please call in tomorrow before 11 a.m.
yes, thank you.
Good luck.
Take care. Next, Ms. Cook is a first-time refusal. We'll give her one opportunity because it's non-violent, despite the new administrative order. All right, next on page 10, Ms. Gugino.
Hello, good morning.
All right, ma'am. Morning. I do find probable cause. Count 1, burglary, occupied dwelling unarmed, although noting the PC notes that there were 2 separate homes. So I'm not sure if they're going to present a separate PC for the other home. Count 2, grand theft over $750, less than $5,000. Count 3 is a pretrial warrant for petty theft that I am not going to touch. So with regards to counts 1 and 2, Mr. Linder, first to you.
Judge, I'm asking that the court set the bond on the burglary charge at $10,000, taking into consideration there's allegations it's about 2 homes. The pending pretrial case is is in mental health court. I'm also showing that Ms. Gugino has a pending possession of methamphetamine from this year, grand theft from 2014, and theft from 2010. So $10,000 bond on count 1, no victim contact, no return, nothing further.
Okay, thank you. Ms. Edgley?
Judge, Ms. Gugino has lived in Broward County for 22 years. Unfortunately, she's currently unemployed, and she doesn't have anyone who can actually post her bond at this time, Judge. If she is released, she will reside in Davie, Florida, and she's interested, Judge, in resolving the misdemeanor case. I understand it's a mental health court, so I'm not sure if the state has an offer on that case.
And I'd ask the court take no action considering it is a mental health.
All right, based on it being a mental health court, I don't know if she's currently competent to proceed or if there are what issues are happening, so I'm not going to make an offer on that case either.
Understood, Judge.
But on count 1, because there are 2 separate homes, I am going to set bond in the amount of $10,000. On count 2, I will leave the $1,000 bond in place. And the pretrial case, I will leave it in place as well. Ma'am, you cannot have any contact with either of the listed victims, direct or indirect, even while you are in custody. Do you understand?
Yes, ma'am.
You also, that means no phone calls, no letters, no having a family member or friend send a message or any other means of communication. I have not said, understood?
Understood.
And you cannot return to any of the listed locations in the police reports. Do you understand?
Yes, ma'am.
And I will provisionally appoint the Office of the Public Defender to represent you during the pandemic, ma'am. Once COVID is over, you'll need to reapply so that they can keep representing you. Ms. Edgley, are you requesting a mental health
I am,
screen?
Judge.
Okay. Okay, so I will sign that mental health screen based on the division that she's in for that petty theft case. We're going to get you a mental health evaluation, Ms. Gugino. We're going to we're going to make sure that you have a doctor to speak to. Good luck to you, ma'am.
Thank you.
All right, next is Ms. Demps on page 6.
She's here, present, Judge of Maine.
All right, thank you. Ms. Demps, good morning, ma'am. I do find probable cause for possession of cocaine. Mr. Linder, first to you, sir.
Your Honor, I'm asking that the court keep the bond in place. Ms. Demps is out on bond right now from an aggravated battery with a deadly weapon that occurred December 2nd of last year. The allegations were that she stabbed her boyfriend in the face, left ear, top of the head, left upper arm, and both hands multiple times with a pair of scissors. She was originally posted a $10,000 bond. Then after she failed to appear at 2 arraignments before Judge Bailey, he issued a capias and ended up setting a $1,000 bond that she posted. She also has a 2018 resisting without violence. Nothing further.
Okay, thank you. Mr. Romero.
Judge, as you heard, she's out on a case. However, she's been abiding by the no contact order. She hasn't seen the alleged victim since then. Now, my understanding is she's currently looking for employment. Unfortunately, she had recently just lost her home, so at this point now she is homeless. However, I'm going to be contacting her father to help post her monetary bond. So at this time, I'm going to be asking the court to provisionally appoint my office.
All right, so I will leave the bond in place, and I will also provisionally appoint the Public Defender's Office to represent you during the pandemic, Ms. Demps. Once COVID is over, you'll need to reapply to make sure they keep representing you. Anything else on her case?
No,
Good luck to you, ma'am. Next is Ms. Brown on page 7, who has bonded. For the record, I find probable cause, grand theft over $750, less than $5,000, petty theft, second degree, third or subsequent offense, possession of anti-shoplifting, controlled device, countermeasure, and petty theft, second degree, third or subsequent offense. Next is the co-arrestee, Ms. Knight on page 7, who's also bonded. For the record, I find probable cause, petty theft, second degree, third or subsequent offense, grand theft over $750, less than $5,000, petty theft, second degree, third or subsequent offense, driving with license suspended or revoked, grand theft over $5,000, but less than $10,000. And that brings us to, we did page 8, that brings us to page 9, Mr. Jones.
No problem, Your Honor.
All right, thank you. This is an ad charge. Mr. Jones, good morning. The state has filed an ad charge on the
Can you lower my bond on the other charges?
Sorry, Mr. Jones?
Can you lower my bond on the other charges?
I cannot, Mr. Jones. That's not what's before me today. You'll have to
Because
go.
on the ag assault, you even said you don't see probable cause on that. I never had no weapon.
So Mr. Jones, I initially it said that, and then the
Then
state.
the victim been in front of you like 4
Pause.
times in the
Are you
last
gonna let
month.
me talk, Mr. Jones, or am I gonna reset you to the end of the docket?
Sorry, ma'am.
All right, Mr. Jones. So I initially said that I remember your first appearance because I didn't have the probable cause for the aggravated assault. Then the state provided it to me in court. And then that is when we had the hearing and I set your bond at $10,000 with pretrial release level 1 on the aggravated assault. And on count 2, I set bond at $5,000. This is an add charge for violation of pretrial release conditions, domestic violence regarding that same listed victim. So you'll have to go before Judge Holden, your new division judge, in order to have file a motion for to reduce your bond. On count on this new ad charge, Mr. Linder.
Your Honor, I'm asking that the court set the bond at $2,500 with the same release conditions, GPS level 1, no victim contact. Considering the $15,000 worth of bond Your Honor already set, also he's being held no bond on 2 separate cases, both involving domestic violence for violations of pretrial.
All right, thank you, Ms. Edgley.
Judge, Mr. Jones has resided in Broward County all his life. He is being held on other charges at this time, Judge. He does have a place to stay when he's released from custody. I would ask the court to set this bond at $500. It is an ad charge. He's being held on other things as well.
All right, thank you. So I will set bond at $2,500 with pretrial release level 1 with the GPS, the same level that I set it at in the other case. And the same order of no victim contact still applies even while you're in custody, Mr. Jones, meaning no phone calls, no letters, no having a family member or friend send her a message or any other means of communications I have not said. Understood?
They subpoenaed her to come to court last week. She didn't show up. They said they couldn't get ready to throw out the case. But she's not.
You understand?
No, not really. But
You don't understand that you cannot contact the listed victim.
yes, I understand that, but she keep popping up on me, breaking my windows, coming to my property. And y'all don't arrest her. I mean, y'all actually did arrest her a few times too.
All right, Mr. Jones, when talking about the facts of your case or everything you're being is saying recording can be used against you. Understood? All right, you also don't possess any firearms, weapons, or ammunition while your case is pending, and I will provisionally appoint the public defender's office to represent you during the pandemic. Anything else on his case that we need to address?
No, Judge.
All right, thank you. So, and then well, that's going to take us to Mr. Garnett on page 9. The listed victim is outside, I believe. So just give me 1 minute. All right, so Mr. Garnett, good morning. I do find probable cause for touch or strike battery, domestic violence. Give me 1 minute. I believe the listed victim is here. Good morning, sir. What is your name? All right, Mr. Garnett, you are the listed victim. And did you want to tell me something, or are you here to just see what happens?
Just see what happens.
All right, Mr. Garnett, thank you for being here, sir, okay? All right, and I believe Mr. Garnett's mother, both Mr. Garnett's mother is also present. Did you want to say something, or are you just here to observe? Okay, so just get one of the attorneys would have to call on you. She says she wants to say something, Mr. Romero. Do you wish to call on the mother? Hold on 1 minute. He's asking his client.
Judge, I'm not going to be calling anyone.
All right, so it sounds like they don't want to tell you anything. They don't want to call on you, but you can tell the state because you're not the listed victim. You're not entitled to speak at this hearing because you're not the listed victim, but you can always let the victim advocates know your position at the state attorney's office. You're sitting in the courtroom, okay? All right, thank you, ma'am. All right, so let me first go to Mr. Linder then. The listed victim's here, but he said he just wants to see what happened. Let me turn this down so I can hear you.
Yes, Your Honor. At this point in time, I'm just recommending an ROR to pretrial and no victim contact.
Okay, thank you so much, Mr. Romero.
No objections.
And does he have somewhere else to live, Mr. Romero? Because I am going to order no victim contact.
I did advise him of that, Judge. He lived with his brother. And at this time, he is aware of the no victim contact. So he's going to have to find a separate place where to reside.
Okay, and does your office need to be appointed?
Judge, he advised me he's going to retain private counsel.
All right, thank you. All right, Mr. Garnett, I am going to release you to pretrial release, sir. That means that you're going to get out today, but you have to call in before 11 tomorrow, so please provide your phone number to pretrial before I continue with my orders.
Phone number 911, right now.
954-809.
Needs to speak up.
A little bit louder, sir.
954-809-1186.
Did you get that? All right, sir, you have to call in tomorrow morning for 11 a.m. And then when you call in, you also have to give them an address where you will be staying. You cannot have any contact with the listed victim, your brother, direct or indirect, until further order of the court. Do you understand?
A little louder.
Yep.
That means that you cannot live with him, you cannot call him, you cannot text him, no emails, no social media, no having a family member or friend send a message to him or any other means of communication that I have not sent. Do you understand?
Perfect.
All right, you also cannot possess any firearms, weapons, or ammunition while your case is pending based on the domestic violence nature. Do you understand?
The answer in the affirmative.
Okay, thank you. Anything else in Mr. Garnett's case that we need to address?
No, Judge.
All right, thank you. And did you get the information for the mother? Because she said she wanted to share something with you all.
Yes, Your Honor, it just has to do with him getting some assistance upon his release.
Okay, thank you. All right, good luck to you, sir. Good luck to you, Mr. Garnett and Miss Garnett. Thank you for being here this morning. All right, so next on page 10 is Mr. DeSantos.
Is he present, Judge in Maine?
All right, good morning, sir. I do find probable cause for false imprisonment of an adult in touch or strike battery, domestic violence. Mr. Linder, I'll go to you.
One moment, Your Honor. Your Honor, out of the state of Virginia, he was convicted of contempt of court from 2017. Also from 2017, trespass, false ID 2017, identity theft 2017, trespass 2016. State of Texas. Forgery of a financial instrument, 2009. Burglary of a dwelling, 2009. Unlawful carrying of a weapon, 2009. Resisting arrest, 06. And (2014) out of Manatee County, battery, resisting without violence, and trespass to a dwelling. In 2018, in Manatee County, he was arrested for battery on a victim over 65 and assault, charges of dropped. Petty theft, 2015, Sarasota County. False reports out of Broward, 2011. Battery, Manatee County, 2017. Trespass, 2018. Trespass, 2019. Another battery arrest in Osceola County in 2014 that was dropped. Theft, Sarasota, 2015. Trespass, 2015. And trespass, 2015. Your Honor, the state is requesting a $3,500 bond on count 1, a $1,500 bond on count 2, considering his prior batteries. This could be upfiled through a felony battery. I also just want to advise the court, my office had contact with the alleged victim. She advised that she wants him to get help and treatment. She advised that there are mental health issues. In order for the Mr. DeSantos' privacy, I won't go into any mention of specific diagnoses. Nothing further.
Okay, thank you, Mr. Romero.
Thank you, Judge. I spoke to Mr. DeSantos. My understanding, he's been residing off and on here in South Florida for over 10 years. At this time, he is not working. Judge, my understanding is he does live with the alleged victim. He's going to have to find a separate place to reside. He doesn't know who's going to be able to contact, to help post his monetary bond. If the court is not inclined to release him on pretrial, what we'd be asking for the court to consider is on count one, a $2,000 bond, and on count two, a $1,000 bond. We're going to be requesting a mental health screening, and we're going to be asking to be provisionally appointed on Mr. DeSantos' behalf, Judge.
All right, thank you. It's a very lengthy history through multiple states and multiple counties as well. I am going to set bond and count one at $3,500, count two at $1,500. Please note also, Mr. DeSantos, based on those prior battery convictions, you may be charged with a felony battery based on priors, a third-degree felony punishable by up to 5 years in prison if the state files charges, as they could. Note the conditions of your bond, even while you are in custody, Mr. Santos, you cannot have any contact, direct or indirect, with the listed victim. Do you understand?
All right. What if the case false or dropped or dismissed? Do they still
Santos, do you understand that you cannot have any contact, direct or indirect, with the listed victim, your mother?
All right.
The answer in the affirmative. All right.
Okay, thank you. That means no letters, no phone calls, no having a family member or friend send a message to her, or any other means of communication that I have not said. Understood?
He said, all right, Judge.
All right, you cannot go back to her home, and you cannot possess any firearms, weapons, or ammunition while your case is pending based on a domestic violence nature. Understood?
He said, all right, Judge.
And I will sign that mental health screen and provisionally appoint the public defender's office to represent him during the pandemic. Good luck to you, sir. Once COVID is over, you will need to reapply to make sure that they keep representing you. Anything else on his case?
No, Judge.
All right, good luck to you, sir. Next on page 11 is Mr. Tucker.
Your Honor,
Yes.
just want to let the court know, my office had contact with the alleged victim this morning. She advised she would be appearing in court. She was actually here last week when I believe Mr. Tucker had a 30-day motion. We just checked, she's not outside, but I just wanted to update the court.
Okay, thank you. Mr. Tucker, good morning. The state has filed charges. They have downgraded the attempt murder charge to a missile into dwelling, so you are now eligible for bond. I do find probable cause for missile into dwelling. Count 5 is been a change as well to touch or strike battery. So Mr. Linder, whenever you get a chance, first to you, he's not eligible for bond on count 2.
I'm sorry, Your Honor? Yeah, yes, Your Honor. And I've provided the court and Ms. Edgley with a supplemental report. There's additional information that the court was not aware of at the original first appearance that I would ask the court to rely upon this morning.
Okay, if you want to go get it, that's fine. Ms. Edgley, have you had an opportunity to read the supplemental report? Okay, she's not here, guys.
Your Honor, she's coming from Judge Holden's courtroom, so I don't mind proceeding now. All I ask is that the court allow her an opportunity to address Your Honor before setting bond.
Sure, if she gets here before we're done with the hearing.
Your Honor, I'm recommending a $75,000 bond, pretrial release for the GPS monitor level 1.
How much?
$75,000.
Okay,
No victim contact, no return, no firearms, weapons, or ammunition. As far as the battery, Your Honor, I reviewed the court's findings, and Your Honor actually found probable cause for battery originally instead of $5,000 bond, so that's what I'm asking the court to set on that. Your Honor, did you have an opportunity to read the PC this morning?
I did.
Okay, you're aware of the level of violence alleged in this case, Your Honor. Additionally, the allegations from the alleged victim that there have been violence previously and that it had been ramping, to quote her words, ramping up over the past couple months. That there was a previous incident involving a firearm, May 25th of this year, also noting that the defendant made admissions. Your Honor, I would note that the state did receive a waiver of prosecution from the alleged victim, Your Honor. What I would note is it is dated June 7th of this year, and the supplemental report I provided Your Honor this morning details jail calls that Mr. Tucker made on June 1st of this year, 6 days prior to the victim signing and preparing a waiver, talking to other individuals about getting the victim to come to the state attorney's office and advising that she wants to drop all charges.
Okay, thank you. Mr. Romero, do you wish to wait for the listed victim, or did you want to go and then we'll put him on recall?
I'll proceed right now, Judge. My understanding is the court is aware he's been in custody since May 31st. Prior to him being incarcerated, Judge, he was working. He was self-employed, did car wash and pressure cleaning. Now, my understanding, Judge, he's going to be residing with his mother. She resides at Miami Gardens. His mother is the only person that can help post his monetary bond, but unfortunately at this time, she is unemployed and looking for work. I do understand the state is asking for $75,000 bond, but unfortunately for Mr. Tucker, that's going to be financially impossible. Judge, I'm going to ask you to set a reasonable monetary amount considering Mr. Tucker's financial resources. I know the state is also asking for level 1. However, because he is working, Judge, I'm going to be asking the court to consider a level 2 pretrial on Mr. Tucker's behalf. That is what we're asking for at this time, Judge.
All right, thank you. So I'll wait on her. He'll be on a brief recall, but while we're waiting, Mr. Tucker, based on the supplemental report, your phone privileges are hereby revoked. It's a privilege, not a right. Please prepare a show order to that effect, Mr. Linder. So he's going to be on a recall till she gets here. All right, next is Mr. Haygood. We'll come back to him when the victim gets here.
Your Honor, just so I know how the court wants the order worded, no phone privileges restricted other than speaking with his attorney of record.
Correct.
Okay.
He can only access, have contact his attorney. They have a separate phone for that. So there's an attorney phone and then everybody else.
That's what I figured. I just wanted to make sure before I put anything down.
Of course, thank you. All right, next is Mr. Haygood.
He's approaching, Judge.
All right, thank you, Mr. Haygood. Good morning, sir. I do find probable cause for trespassing in an unoccupied conveyance. Count 2, resisting without violence. Count 3, driving with a license suspended, second offense. Noting it's a listed victim. On count 1, it's an alleged stolen car. I don't believe the state has an offer. So Mr. Linder, what is the state's recommendation?
Your Honor, I'm just recommending an ROR to pretrial.
All right, thank you. Mr. Romero?
One moment, Judge.
Haygood.
Judge, no objections.
All right, thank you. Okay, so Mr. Haygood, I am going to release you to pre-trial release. That means that you're going to get out today, but you have to call in before 11 a.m. tomorrow. Please provide your phone number to pre-trial before I continue with my orders.
613769521.
Did you get that, Ms. Worrell? Okay, hold on. Let me turn this up. You got to speak up, please.
376-9521.
What were the first 3 digits that you cut out?
561.
Okay, thank you. All right, Mr. Haygood, you cannot have any contact with the listed victim of the automobile that you were allegedly trespassing in, direct or indirect. That means no phone calls, text messages, emails, social media, having a family member or friend send a message to them for you. Do you understand?
Nice and loud.
Yes, ma'am.
All right, you also cannot drive without a valid driver's license. It's alleged that your driver's license has been suspended since 2014. Do you understand?
Yes, ma'am.
All right, so the whole case is on pretrial, Ms. Worrell, just so it's not confusing. I'm going to put the entire case on pretrial, and does your office need to be appointed?
Yes, Judge.
And I will provisionally appoint the Office of the Public Defender to represent you during the pandemic, sir. Once COVID is over, you will need to reapply to make sure they keep representing you if this case is still pending. Anything else on his case?
No,
No,
Judge.
Your Honor.
All right, thank you. Good luck.
And Your Honor, I just want to advise the court, the alleged victim of Mr. Tucker's case is now present in the court.
All right, thank you. Let's go back to Mr. Tucker on page 11. Does she want to come to the podium? You guys saw me put it on recall. Okay, yeah, that's what I was asking, if she wanted to come up. All right, ma'am, good morning.
Good morning.
You are the listed, can you put your purse down, please? You can't come to the podium with the purse. It's security. It's for security purposes. No problem. All right, ma'am, you are the listed victim on this case. What is your name? All right, Ms. Ray, you are the listed victim. Are you here to see what happens, or did you wish to tell me something?
I want to see what happens, and also I would like to stay away order dropped.
Okay, so you answered the question. Okay, so you need to raise your right hand for me, ma'am. Do you swear or affirm to testify to the truth, the whole truth, and nothing but the truth?
Yes.
Okay, put your hand down and please state your name now that you're sworn. All right, ma'am, you are the listed victim and you're here without an attorney. So I need to advise you that you previously spoke to law enforcement. So anything you say today can be used against you at a later date. Do you understand?
Yes.
All right, Ms. Ray, what is it that you wanted to say to me?
I just wanted to stay away
Judge,
order.
unmute her microphone because we can't hear.
Oh, she's muted, guys. Hold on. All right, thank you. All right, thank you for that, Mr. Romero. So what is it that you wanted to say, Ms. Ray? Sorry, you were muted.
Yes, I would like to, I still like to all the time, but also to have the stay away order when the bond is closed.
All right, I understand what you're saying, Ms. Ray. However, what I have before me is allegations that you were, somebody spoke to you or got to you based on the allegations from jail calls, that he contacted somebody to contact you to go to the state attorney's office and file a waiver of prosecution. And it's alleged the next day that you did in fact file one. Does any party have any questions for Ms. Ray based on her testimony this morning?
Your Honor, frankly, based on the allegations in the probable cause affidavit and supplemental report, I do not have any questions at this time.
Thank you, Mr. Romero.
Judge, at this time, no question.
All right, thank you. Thank you for being here, Ms. Ray. However, I am not going to drop the stay away order because of what I have before me, allegations that it's alleged that somebody tampered with you or spoke to you to get you to file a waiver. So at this time, there will need to be a motion before the division judge, but I am taking no action based on these very concerning allegations, okay? All right, thank you for being here. Please take a seat. All right, understanding what both parties request, I am going to set bond in the amount of $75,000 on the missile into dwelling based on the concerns, based on the allegations that Mr. Tucker contacted someone to get to the alleged victim to file that waiver of prosecution, which is alleged she filed the next day after that phone call was made. Count 5 will be reinstated at $5,000. Pre-trial release level 1 with the GPS strict house lockdown. Once he post bond, if he's able to post bond, all previous conditions apply. No contact, direct or indirect, with the listed victim, no firearms, weapons, or ammunition. And should he post his bond, you shall surrender all firearms, weapons, or ammunition within 24 hours of your release to police, as I already advised you of at the initial first appearance. Again, I am revoking his phone privileges except for his attorney based on these allegations. All right, anything else in Mr. Tucker's case that we need to address?
Just that will be his new bond, because we have already updated the rest of the charges including his bond.
I think the state filed an information.
That's correct, Your Honor.
Okay.
They're only filing on 2 and.
Hold on. Okay. All right, no problem. So those are the bonds. It's now 80,000 total. Okay. All right, since the state declined to file the other charges. All right, and I will sign that order revoking his phone privileges. Anything else on Mr. Tucker's case? All right, good luck to you, Mr. Tucker. All right, be in touch with your attorney. That's the only one you can contact. All right, thank you, Ms. Ray, for being here. Good luck to you. You too, ma'am. Next is Mr. Picard on page 12.
Nice to meet Judge Maine.
All right, Mr. Picard, good morning. I do find probable cause for this capias for a battery. Does your office need to be appointed? Mr. Romero, does your office need to be provisionally appointed?
Yes, Judge, I'm going to be asking to be provisionally appointed.
All right, no problem. So I will provisionally appoint the public defender's office to represent you during the pandemic, sir. Once COVID is over, you will need to reapply to make sure that they keep representing you. You cannot have any contact, direct or indirect, with the listed victim while this case is pending, sir. Do you understand?
Yeah.
All right, that means no phone calls, emails, having a family member or friend send a message to them, or any other means of communication that I have not said. Understood?
Yeah.
All right, good luck to you, Mr. Picard.
Judge, I'm going to be asking the court at this time to address the bond pursuant to Mr. Picard's instructions to me. My understanding, he advised me that he is on pretrial. He's been checking in, been calling in on a regular basis. He uses a friend, he's homeless, so he uses another friend's phone in order to contact pretrial, in order to contact them. My understanding in speaking to him, he was trying to contact pretrial recently to try and see when was his next court date, but unfortunately his friend wasn't around, so he couldn't use the phone in order to find out his future court date. He advised me, had he known when his court date was, he would have appeared in court. So that's why he is asking me at this time if the court, if pretrial can confirm that he was checking in, if the court would consider releasing him on pretrial once again.
I'm asking that the court keep the bond in place. If he can't post it, he'll see Judge Brown. This is now the third capias that's been issued this year alone on this case.
All right, I'm going to take no action. It's a third miss from court. He's going to have to see Judge Brown. Good luck to you, sir. All right, next is Mr. Langdell on page 14, who's refused, and we're going forward without him based on the new administrative order. He's refused to come to court. We're proceeding without him. I do find probable cause. I received the updated police reports from the state. Did you have an opportunity to review those, Ms. Edgley?
I did, Judge.
All right, thank you. Did you want me to attach it to the clerk's packet, Mr.?
Probably best, Your Honor, just so there's a record of what the court did find, base the determination on.
Okay, any objection to that, Ms. Edgley, attaching the police reports to the clerk's copy? All right, thank you. So without objection, I do find probable cause for failing to register as a sexual predator. Count 2, sexual predator failing to re-register as required. Count 3, burglary with an assault or battery. I also make a finding of proof evident presumption. Great, I am going to hold him no bond. He has no ties, is allegedly from Ohio 6 months ago, and based on the alleged sexual battery on a child under 12 years old as the basis for him being registered, requiring to register as a sexual predator. I do find him to be an extreme danger to the community based on these allegations that the listed victim is somebody regarding that 05 sexual predator conviction. Mr. Linder, first to you. Any surprise in the state's recommendation on 1 and 2?
Your Honor, I see a 2015 resisting without violence out of Broward and a 2019 trespass. I can't advise the court. I don't know if it showed in the database when you checked, Your Honor, on the lewd and lascivious molestation. He violated probation and was sentenced to 15 years in Florida State Prison as a habitual offender. Based on that, Your Honor, the allegations in the new charges and his registration status, I'm recommending a $10,000 bond on counts 1 and 2. Pre-trial release of the GPS monitor level 2, no victim contact, and obviously no victim contact on the bird bat. I'm asking that the court keep that in no bond.
I have a question. So is the victim in count 3 the child from the 05 case?
I'll check, Your Honor. I didn't necessarily think that was the case, but I will certainly check.
Okay, thank you, Mr. Romero. Do you have anything since he refused?
Judge, I have nothing since he refused, and I know the court went forward over defense objection, but I'm just going to be asking to be provisionally appointed on Mr. Smith Lindell's cases.
So Mr. Romero, what's the legal objection? Because based on the new administrative order that was released yesterday, if the first appearance judge determines a detained individual voluntarily refuses to attend, the first appearance judge shall determine probable cause for the absent individual as required by law or rule of procedure. What is the legal objection? You advised me he refused.
The key word, Judge, is voluntarily. As this court knows, and as routinely happens, sometimes people are indisposed, they're sick, and they don't feel well. It's not because they're voluntarily absent themselves from these proceedings. He is right now, if the court looks at the docket, he is in 4A. That location is detox. Typically, we know those people in detox in that facility, there are medical issues going on. So at this time, Judge, I do understand the court is going forward, but it is over defense objection.
All right, thank you. Over defense objection without finding there to be a legal basis to not proceed.
Your Honor, to answer the court's question, I am looking at the name of the alleged victim of that 2004 case. There does not appear to be any connection between the two, Your Honor.
Okay, thank you.
And Judge, if I may be heard just as to the court's finding regarding proof evident and presumption great, I would note for the court that that's an extraordinarily high burden of proof, Judge. And in this case, we just have the probable cause affidavit. We don't have really any detailed information regarding the relationship of Mr. Lindahl to the alleged victim here. Furthermore, there's no surveillance footage placing him at the scene of the crime. There's no independent witnesses that observed the battery. And so, Judge, my argument is that the state in the allegations in the four corners of the probable cause affidavit do not amount to proof evident presumption great.
All right, thanks, Ashley. It's over defense's objection. It's alleged he allegedly broke into the victim's home by defeating the bedroom window lock mechanism by punching the window. Once inside, he went to the kitchen, armed himself with a kitchen broom, returned to the victim's bedroom, struck her on the head with a broom, and then when she asked him to drop the broom, he began punching her in the face while saying, "You're going to die, bitch." It's then alleged the victim stated the defendant is angry and blames her for being homeless. He was observed, the victim was observed with extensive swelling, bruising, and a minor laceration to her face, and provided a sworn statement and photos of her injuries to that effect. Based on all of that, it's over the defense's objection. I know it's a high burden, but I am deeming him a severe danger to the community based on his status as a sexual predator, based on a crime of violence to a child, and his refusal or alleged refusal to register as a sexual predator. He is going to be held no bond on that count. On counts 1 and 2, $10,000 each. Should he post bond, pretrial release level 1, strict house lockdown. Based on my findings that he is an extreme danger. No victim contact with the victim on count 3. No return. And the no victim contact is direct or indirect. No contact with any minors under the age of 18 years old while his case is pending, and I will provisionally appoint the Office of the Public Defender to represent him during the pandemic. All right, so that takes care of Mr. Lindahl's case. Next on page 14 is Mr. Strong.
Judge Maine.
All right, thank you. Yes, ma'am.
A question on Lydell.
Yes, ma'am.
No contact with minors going to apply to 1 and 2, correct?
Correct. No victim, no contact with minors is on 1 and 2.
Okay, thank you.
All right, no problem. Thank you. And Mr. Strong, good morning, sir. I do find probable cause for impersonating a law enforcement officer, count 2, trespassing an occupied structure or conveyance, allegedly somebody's home or an evicted home. Mr. Linder, first to you.
Your Honor, I'm just asking that the court keep the bond in place on count 1 with an order of no return. He was arrested July 3rd for trespassing in Sawgrass Mills. He was ROR'd at his first appearance. He also has a petty theft from this year. Trespass, 2 trespasses in 2019, with a loitering and prowling in 2019, resisting without violence 2014, battery 05. There's other priors, Your Honor, but I'll stop there.
Thank you, Mr. Romero.
During my conversation with Mr. Strong, I learned that he's been residing here for his life. He advised me he has no one to contact to help post his monetary bond. He's requesting the court consider releasing him ROR to pretrial, Judge.
All right, thank you. He's already out ROR on other offenses. He's not a candidate for pretrial based on the allegations that he was impersonating a law enforcement officer. It's alleged he had a BSO badge around his neck and was adamant that he was allegedly a lieutenant with the department. I am going to leave the bond in place with an order of no return to the incident location. I will also provisionally appoint the public defender's office provisionally to represent you during the pandemic, Mr. Strong. Once COVID is over, sir, you will need to reapply to make sure they keep representing you. Good luck to you, Mr. Strong.
But I'm going to be asking for a mental health screening order.
All right, makes sense. So I will sign that as well. All right, thank you for that. Anything else on his case?
No, Judge.
All right, good luck to you, sir. All right, next is Mr. Diaz-Garrido.
She's approaching, Judge. He's approaching. Sorry.
All right, sir, good morning. I do find probable cause for armed carjacking with a firearm or weapon. I also make a finding of proof evident presumption great, but I do so without prejudice. I am going to hold you no bond based on these allegations. On count 2, fleeing with disregard to safety or persons or property, aggravated. Count 3, possession of weapon or ammo by convicted felon. Count 4, aggravated assault with a deadly weapon, actual possession of a firearm. Mr. Linder, first to you on 2 through 4. I know he has no ties and is from Cuba.
Yes, Your Honor, based on the allegations, and I just want to know for the record, I'm not sure where the $10,000 on the firearm offense came from.
I'm not sure, but we have to set it before. It's for me to set.
No, of course. I just wanted to note that because I see that there, but I you know.
Judge, it was on the paper.
Yeah, I saw that. Thank you, Ms. Cooper. I just didn't know how it got there. One moment, Your Honor.
And Judge, he's in the South Florida Reception Center. He has an EOS date of 7/18.
And excuse me, I just want the court to know what he's being released on.
Okay, thank you. Sorry about that.
What he's being released on is possession of firearm or weapon or ammunition by an adjudicated delinquent. I'm showing an arrest in 2019 in Mississippi for possession of controlled substance. There's no disposition. He was picked up in Nebraska in 2015 on a failure to appear, contempt of court. He ended up pleading to a minor in possession. Doesn't specifically say what in possession of what, could be alcohol, I'm not sure. Or but based on the allegations here and that he's just wrapping up a prison sentence for a weapons firearm offense. And I'm also showing a 2016 burglary of a dwelling out of Dade. And fleeing and eluding law enforcement from this year out of Dade, Your Honor. It looks like that's what he got picked up on when they ultimately arrested him on this warrant. Your Honor, I'm asking for a $15,000 bond on count 2, a $15,000 bond on count 3, and a $25,000 bond on count 4. No victim contact, no possession of any firearms, weapons, or ammunition. Nothing further.
And Judge, if I may be heard as to proof evident presumption, great.
Sure, go ahead.
Judge, I would just note that there's nowhere in the probable cause affidavit that indicated that a gun was found. In fact, I believe that there was a notation that a gun was never found. There's no independent witnesses as far as the probable cause affidavit indicates. And Judge, I would just remind the court that this is an extraordinarily high burden of proof. And based on the 4 corners of the probable cause affidavit, there is insufficient evidence that he was actually armed during the carjacking.
Okay, thank you, Ms. Edgley. I'm maintaining my finding. Thank you. All right, so Mr. Romero, to you on 2 through 4, sir.
Judge, my understanding, speaking with Mr. Diaz-Garrido, he's been residing off and on in South Florida since 2003. My understanding, he lives with his mother in Miami, so he does have ties to the community. My understanding, he's also been in custody, I believe in Dade County. He was extradited up here. He's been in custody for several weeks, Judge. My understanding is his mother knows he's in custody, but is not going to be able to afford the $55,000 bond the state is asking for, Judge. I'm going to be asking to be provisionally appointed on his case, and I'm going to be asking for a mental health screening order, Judge, on his behalf.
All right, so I will sign that mental health screen order. I'll also provisionally appoint the Office of the Public Defender to represent you during the pandemic, sir. Once COVID is over, you will need to reapply to make sure they keep representing you. I am also deeming him a flight risk based on these allegations that he fled allegedly at speeds of 118 miles per hour and took officers from Fort Lauderdale to Miami-Dade County on that fresh pursuit after allegedly carjacking the victim at gunpoint. On counts 2 and 3, $15,000 bond. Count 4, $25,000 bond. No return to the incident location off of Las Olas. No contact direct or indirect with the listed victim. Do you understand, sir? You may not know who the listed victim is, but you cannot send letters, have a family member or friend send a message to the listed victim or any other means of communication. I have not said. Do you understand? You also cannot possess any firearms, weapons, or ammunition while your case is pending. Good luck to you, sir. Anything else on his case?
Your Honor, you said 15 on 2 and 3 and
25 on 4. No bond on 1.
thank you.
Thank you. All right, next is Mr. Davenport on page 15.
Judge, he's here present. Just to refresh the court's recollection, Mr. Davenport advised me that his family hired private counsel.
All right, thank you. Mr. Davenport, good morning, sir. It's my understanding that your family may have obtained a private attorney to represent you today, correct?
Yes.
Do you know the name of that attorney, or do you have a phone number for your family member that Mr. Romero is able to call to find out who that attorney is?
Mom, dad, brother, sister. What is the name? Okay. What is it? Okay, hold on, I'm gonna contact my colleague right now. Hold on. Judge, may I have a moment to contact my colleague, Ms. Edgley?
Of course.
What's the
What's the extension in the courtroom? Do you know?
It's 6172.
okay, hold on. Thank you, Judge.
All right, thanks. While we're doing Mr. Amick, despite the first appearance, AO, I am going to give him one-time reset based on his non-violent offense. Is it Amick? Oh, sorry. He's no bond on count 1. Thank you.
Yeah, I sent an email.
Do they want to do anyone else while we're waiting?
Judge, we could call Joseph Amick. He's the next person. He was a refusal. I was going to be asking the court, this is non-violent, if the court will consider resetting it for tomorrow.
Yes, not a problem. We talked about that at the beginning. Even though there is the new AO, I am going to reset him one time because it's non-violent.
Thank you, Judge.
No problem. Can we do Mr. Daniel next while we're waiting? We'll just come back to Mr. Davenport at the end of the docket while we find out if we can get his attorney's name.
Yes, Judge. I just wanted to inquire with my colleague if she had any probable cause argument in reference to Mr. Daniel once the court reaches that point.
All right, so Ms. Edgley, sorry, 1 minute. Do you have a PC objection on Mr. Daniel on page 15? Mr. Romero wanted to know if we could go forward. Okay, thank you. She said no. All right, so Mr. Daniel, good morning. I do find probable cause for aggravated battery with a deadly weapon. Mr. Linder, first to you, sir.
Your Honor, I'm recommending a $20,000 bond, no victim contact, no return, no possession of any weapons, noting that Mr. Daniel allegedly stabbed the victim, Your Honor, and my concern is not only that he allegedly stabbed the victim, but that he stabbed him in the victim's neck. Thankfully, it would appear that there was not serious injury sustained, but he did have to be transported to Broward General for treatment, Your Honor.
Okay, thank you. I also note he has no ties and it's alleged he's from Ohio. Mr. Romero, to you.
That is true. He is from Ohio, Judge. He advised me that he's been residing here in South Florida a couple months now. He's not working. He is homeless. My understanding, Judge, and speaking with Mr. Daniel, the other individual, I believe the alleged victim, was another homeless individual. Mr. Daniel did advise me he was defending himself. He was being attacked by 3 other individuals. And that's how these allegations came to fruition. I did advise him he will have his day in court in order to present a stand your ground motion. But at this time, Judge, there's no one that he can contact to help post his monetary bond. He's asking, we're asking to be provisionally appointed on his behalf, Judge.
All right, thank you. I will provisionally appoint the Public Defender's Office to represent you during the pandemic, sir. Once COVID is over, you'll need to reapply to make sure they keep representing you. Sir, the conditions of your bond, even while you're in custody, I am going to set the bond as requested by the state at $20,000 based on the allegations in the probable cause affidavit. You cannot have any contact, direct or indirect, with the listed victim. Do you understand?
Yes, ma'am.
Okay, that means even while you're in custody, you cannot call, you cannot send letters or any other means of communication that I have not said. Do you understand?
Your Honor.
You also cannot possess any weapons while your case is pending, and that includes knives. Do you understand? And you cannot return to the incident location, the 7-Eleven, and the police reports. Do you understand? All right, thank you. Anything else in Mr. Daniel's case that we need to address?
No, Judge.
At this time, Judge.
All right, thank you. Good luck to you, sir. All right, next is Mr. Martin on page 16.
He's approaching Judge Maine.
All right, thank you. Good morning, Mr. Martin. I do find probable cause for a drug paraphernalia and possession of methamphetamine. Flip those backwards. The docket was backwards for some reason. Mr. Linder, first to you.
Your Honor, I'm recommending ROR to pretrial random testing just on count 1.
Okay, thank you. Mr. Romero.
Objection, Judge, just asked him to be provisionally appointed.
All right, thank you. Okay, Mr. Martin, so I am going to release you to pretrial release on count 1, the methamphetamine charge only. That means you're going to be released today, but you have to call in before 11 a.m. tomorrow. So please provide your phone number to pretrial when you get a chance out loud so we can write it down in their file.
754-303-6723.
Sorry, you broke up 6 what?
6723.
All right, thank you. Did you get that, Ms. Royal? All right, sir, you cannot use any drugs and you cannot use any alcohol while your case is pending because you're going to be randomly screened for drugs and alcohol while your case is pending, understood? An initial screen for drugs, that'll be your baseline, and then on later testing, if the levels don't go down, but instead stay the same, get higher, there's a new drugs or alcohol introduced, you could be violated, understood?
He said yes, ma'am.
Okay, thank you. And I will provisionally appoint the Office of the Public Defender to represent you during the pandemic, sir. Once COVID is over, you'll need to reapply to make sure they keep representing you. Good luck to you, Mr. Martin.
This is the number you're calling. Make sure you call that.
And Mr. McKellar on page 17 is a medical reset, but he'll be deleted and put back on once he's released from the hospital. Okay, so do we want to do the FMN docket while we're waiting on Mr. Davenport's information, or did you get that?
Judge, I do have an update. It's my understanding that Andrew Ryer is in the process of being retained and that someone is expected to be here in a few minutes to represent Mr. Davenport. Andrew Ryer from the law firm Ryer Jordan.
Okay, thank you. Andrew Ryer, R-Y-E-R?
I think it's R-I-E-R.
Oh, okay, thank you. All right, so he'll be on recall if his attorney gets here before we're done with the docket. Otherwise, it's going to be reset until tomorrow, or we'll ask him if he wants to. I mean, we'll get there.
Judge, we on the, if the court wishes, we can 30-day on the second look docket.
Yep, that's what I was going to suggest while we're waiting on Mr. Davenport's attorney to get here. So let's start with the FMN docket. Who do we have first?
Judge, if you want, we have an Eddie Butler here.
All right, so let's call Mr. Butler. He is on the second look docket.
Judge, my understanding.
Sorry, go ahead.
My understanding, Mr. Butler has been in custody since the 8th of July. He advised me, Judge, let me look at my notes. He could have sworn that he got released on pretrial. When I advise him, when I look at BSO case, there's still a monetary component. My understanding, he's been residing here his whole life. He right now looking for employment. He hasn't been successful. He is homeless. No one's going to be able to post his monetary bond. He's asking to be released on pretrial release.
It was PTR pending.
I'm
Yeah,
sorry?
It was PTR pending verification.
Yeah,
Oh, okay.
and I don't know what information was provided to Judge Murphy because we're being advised he's homeless. I mean, I don't know what the point of putting someone on pending verification if they're advising they're homeless would be.
Okay, thank you. So, Mr. Romero, the information that was provided was that he was pretrial release pending verification or the monetary bonds.
Judge, in that case, unfortunately, nobody's going to be able to verify his address. Considering at this time these are nonviolent offenses, I'm asking if the court would delete the verification and release Mr. Butler to pretrial release. He is aware, I did go over it with him, what is expected of him. He has to call in at least twice a week. He has to appear to all his court dates and he can't pick up a new law offense. He is aware of that. He says he will abide by that, Judge.
Okay, thank you, Mr. Linder. What's the state's position?
One moment now. Well, Your Honor, so far I'm showing every recent arrest he's had. He's either been on a violation of probation or a capias. The capias was on a grand theft where from 2019, where he was released to pretrial, and then apparently he didn't show up in court. One moment. Yeah, it would just appear that every time he's been on any type of supervision, Your Honor, he hasn't been able to follow through with what's required of him.
Any violent offenses in his history, Mr. Linder?
One moment. He had an old unlawful illegal firearm offense, and he had a burglary conveyance about 14 years ago.
All right. All right, so over the state's objection, I am going to release you to pretrial release, Mr. Butler, but you cannot have any contact with the listed victim of the grand theft auto, direct or indirect. Do you understand?
Yes, ma'am.
And you cannot return to the, is it an incident or a location for the petty theft or subsequent offense? I can't see the reports in my system for some reason.
One moment.
Or is it the victim from the grand theft auto?
Do you have
Well, I'll just say no return to the incident location as well, Mr. Butler. Do you understand?
Yes, ma'am.
All right, so that means you're going to get out today, but so please give pretrial your number because you have to call tomorrow before 11 a.m. What's your phone number?
754-46-6499.
It cut out 754
754
254
754-246
246 64 99. Okay, thank you, sir.
I have it, and also if the courts can remind Mr.
Hold on.
Butler that he needs to check in 2 times per week as required, because previously when he was on pretrial supervision,
This one.
the butler refused to check in as required by court.
Okay, thank you. So, Mr. Butler, not only do you have to call in tomorrow before 11, but you also have to call in at least 2 times per week as instructed by your pretrial officer. Do you understand?
Yes, ma'am.
All right, good luck to you, Mr. Butler. Please call in tomorrow and continue to call in.
Okay, no problem. Thank you. Good. Judge, the next person was, I'm being told, what was the name of the guy? Mr. Moyet, Judge. Mr. Armando Moyet.
All right, he's on page 2 of the 3040.
Yes.
All right, Mr. Moyet, good morning. Mr. Linder has the state filed charges on Mr. Moyet.
He's entitled to release.
Okay, are there any conditions that you're asking me to keep in place?
One moment, Your Honor. just an order of no return.
All right, thank you. Do you have this phone number, Mr. Romero?
I'm gonna get it right now, Judge.
All right, thanks.
Thank you, Judge.
Sir, the state has not filed an information yet. That does not mean that they still cannot file charges against you, but for now, they have not filed it within a certain time frame. So you are going to be released outright today, but you cannot return to the incident location. Do you understand?
Nice and loud. Yes, ma'am.
All right, sir. Good luck to you, Mr. Moyad. Mr. Romero has advised me he's taken down your phone number, so be in touch with your attorney and please continue to look on the clerk's website to see your next court date if the state files charges. Good luck to you, sir. Who else do we have?
Judge, we have Mr. Come on up. Mr. Nathaniel McGee, he is on your second look docket, Judge.
All right, so this is Mr. McGee on the second look for possession of cocaine. He's on page 5, Mr. Linder.
I'm fine with the R1, the pretrial random testing, Judge.
Okay, thank you. That's what he wanted?
Yes, Judge, that's exactly what he wanted.
All right, so Mr. McGee, you're going to get out today, but you have to call in a pretrial release before 11 a.m. tomorrow. Please give your phone number to the trial.
Your phone number, sir.
954-857-6382.
Mr. McGee, you can't use any drugs or alcohol while your case is pending, and you can't, because you are going to be randomly screened for drugs and alcohol, understood?
Yes, ma'am.
All right, if there's an initial screen for drugs, that'll be your baseline. If on later testing, the levels don't go down, but instead stay the same, get higher, or there's a new drug or alcohol introduced, you could be violated, understood?
Yes, ma'am.
All right, anything else in Mr. McGee's case?
Nothing else, Judge. That's the
Good
phone.
luck to you, sir. Call in tomorrow, okay?
Good luck, sir. Judge, we could go ahead and delete Mr. Rolandos Rios Perez. My understanding is he bonded. He was on your second look docket.
Okay, so we will delete Mr. Rios Perez because he is bonded.
Anybody else? That's it. Judge, there's nobody here at Maine and except that one case that's on recall.
Okay, thank you. So let's move forward with the other facilities. Who do we have here in North Broward?
Martin Sabata on the second look down.
Okay, thank you. So this is Mr. Martin on page 6 of the FMN docket for second look. Mr. Linder, first to you.
One moment, Judge.
No problem. He's on page 6.
Yeah. Your Honor, his criminal history is a 2018 dealing in stolen property, false ownership info, and a pawn item and grand theft, sentenced to 33 months state prison. 2018 petty theft, 2017 aggravated battery against a pregnant victim with a violation of probation. Petty theft 2017, grand theft 2017, a year and a day state prison. DWS habitual offender resisting without violence 2016, VOP year and a day. Possession of cocaine, attempted tampering with evidence 2012, resisting without violence 08. Possession of cocaine 06, possession of cocaine 04, possession of cocaine with intent 04. Burglary of a dwelling 95. Nothing further.
Thank you, Ms. Edgy.
Judge, Mr. Martin has lived in Broward County his entire life. He has strong ties to the community. He has a home to go to when he's released from custody. He was employed at the time that he was arrested. He did tree work for a landscaping company and hopes to be able to continue to do so when he's released from custody. Unfortunately, Judge, he's not able to afford any bond as evidence by the fact that he remains in custody. I would ask that the court would release him on his own recognizance to pretrial release. He's willing to comply with any conditions that the court would impose upon him.
All right, thank you. Based on the very lengthy history, including the crime of violence alleged, actually not more than alleged, the crime he was convicted of for aggravated battery and a pregnant female, I am taking no action. Good luck to you, sir. You'll have to file a motion before your division judge. All right, we still have a couple of people left. Where's Mr. Baptiste?
No problem, Your Honor. They all coming up. You all know.
All right, Mr. Baptiste is here. This is another motion for 3040. Good morning, Mr. Baptiste. Mr. Linder has escaped all charges.
Yes, Judge.
All right, so Mr. Baptiste, at this time, the state has filed an information against you, so your motion for ROR will be denied. Good luck to you, sir. Be in touch with your attorney so they can explain to you the next steps in the proceedings, okay? All right, anything else on his case?
No, Judge.
All right, thank you. Next is Ms. Howard on page 3. You've waived her presence.
That's correct, Judge. And my understanding is that the state has filed charges.
Is that correct, Mr. Linder?
Yes, Judge.
All right, thank you. So the information has been filed, so her motion for ROR will be denied. And next is Mr. Jimenez on page 5 of the FMN docket.
No problem, John. Mr. Mayor.
Thank you. All right, Mr. Jimenez, this is another motion for 3040. Mr. Linder, has the state filed charges?
No, Your Honor. I would just ask that the court keep the no victim contact order in place.
Okay, thank you. Ms. Hedgley, do you have his phone number for your file?
I don't, Judge, but I would accept it.
Okay, Mr. Jimenez, please give your attorney right now your phone number so they can have it in file.
I don't have a number you can reach me on. I have an email.
He has an email.
That'd be great.
It's FUQSU 6667 @gmail.com.
She needs to say one more time, please.
Fuxu 6667 @gmail.com.
Spell it out.
FUQSU 6667 @gmail.com.
All right, she got it. Okay, Mr. Jimenez, you are going to be released today because the state has not filed charges. Just because they have not filed charges yet does not mean that they still cannot file the charges. Do you understand?
Yeah.
All right, the conditions of your release, even though you're being ROR, are still that you cannot have any contact with a listed victim, direct or indirect. You understand?
Okay.
All right, and so just be in touch with your assigned attorney and look on the clerk's website to see if your charges are going to get filed. Good luck to you. Okay, he just walked away. All right, and then next is last is Mr. Wells on the FMN docket.
No problem, John.
All right, thank you, Mr. Wells. Good morning, sir. Mr. Linder, this is a 3040 motion. Has the state filed charges?
Yes, Judge.
All right, Mr. Wells, the state has filed charges against you. Your motion for ROR will be denied. Please be in touch with your attorney so that they can let you know the next steps in the proceedings. Anything else in Mr. Wells's case?
No, Judge.
No, Judge.
All right, good luck to you, Mr. Wells.
Your Honor.
So that takes care of our second look, our FMN, and we just have one case left for Dalencourt, and his attorney is not here, correct?
No, what happened with Arnold Mitchell?
He was deleted because he's in mental health court. You're welcome. So what do you guys want to do? Do you want me to let me have a conversation with Mr. Dalencourt since it's 10:31 and his attorney is
Would
here.
you advise the clerk on still need something saying that it's deleted so we can show what happened?
Okay, guys, we still need something on Mr. Arnold that says that he's been deleted. It's right here. It's the second one back. This thing here, please. So it would be right here, this first page. All right, thank you. All right, Mr. Dalencourt, good morning, sir. Your attorney, I've been advised Andrew Ryer is going to be your attorney, but he's not here. What do you want me to do? Do you want me to reset your case until tomorrow? And now that you have his name, do you want to contact him to tell him to log on tomorrow by 8:30 a.m.? Or actually come in, he has to come in person. He needs to be in person by 8:30 a.m. Is that what you want to do? Or do you want to go forward without him? Oh, sorry, yes, ma'am. Oh, ma'am, no, he needs to be in person.
Oh, sorry.
So hold on, he's on the phone right now, Mr. Dalencourt, with the assigned public defender in the courtroom. So he made a request by Zoom. The attorneys need to be in person pursuant to administrative order. He has to be here in person. So let's see what he says. Where, how far is he? Okay, I was gonna say, because their office is in Miami.
I know I'm familiar with the neighborhood office and then 5 hours.
Okay, so Mr. Davenport, we're going to take a 5-minute recess. If your attorney gets here within that time frame that we're going to recess, then we'll call your case. If he doesn't get here, then we're going to reset your case till tomorrow, okay? All right, so just take a seat because I've been told that your attorney is sending somebody from that law firm, okay? All right, so we're going to be on a brief recess.
We were so close to being done at 10:30.
All right, so let's go back on the docket for Mr. Davenport. Is he there? All right, thank you so much. Mr. Davenport, I've just been advised that it looks like they're coming from Miami, so they will not be here in time for today. So I am going to reset your case for tomorrow for your attorney to be here. Do you want the office number? Do you want to write down the office number so that you can contact Mr. Ryer? Let him know that he needs to be here before 8:30 in person.
He said yes.
Okay, thank you. So your attorney's name, Andrew Ryer, R-I-E-R. His phone number is 305-899-1212. That's the office number I got off the Florida Bar website. So you can contact him to discuss your case before tomorrow as well, okay? Good luck to you, Mr. Davenport. We will see you tomorrow morning. Your attorney will be advised that he has to be here in person as he was today, okay? Good luck to you, Mr. Davenport. See you in the morning. All right, guys, any questions? All right, everybody, have the rest of your morning, and we'll see you tomorrow.
Good luck.
All right, take care.
We're going to be on it tomorrow.
They're working on it. They worked on it a lot yesterday, and they're going to continue to work on it today. They're just having technical difficulties with the monitor.
I got you. No problem, Judge.
All right, guys. Hopefully, we'll be back on the actual old way. Otherwise, it will be this Zoom.
Take care, guys.
All right, thanks. Take care.